A police officer walks up to you on the street. He looks you in the eye and says, "Show me your ID." Most Americans reach straight for their wallet without even thinking. But here's what almost nobody knows. In at least 24 states, you may not be legally required to do that. And in some states, you absolutely are. The terrifying part? Getting it wrong in either direction can get you arrested. Today, we are breaking down the exact law, backed by U.S. Supreme Court decisions and real state statutes, on when you must show your ID to police and when you legally don't have to. This is information that can protect your freedom, and almost nobody teaches it. Let's get into it. Most people watching this right now believe one of two things. Either I always have to show my ID when a cop asks, it's just the law, or I know my rights, I never have to show my ID, period. Here's the truth that makes lawyers cringe when they hear this on social media. Both of those answers are wrong. The correct answer is, it depends. It depends on what state you're in. It depends on whether you're walking, driving, or standing still. It depends on whether the officer has what's called reasonable suspicion. And it depends on whether you've been detained or you're just having a voluntary conversation. These are four completely different legal situations, and treating them the same is how innocent people end up in handcuffs. So let's build this from the ground up, starting with the foundation of all of this, the Fourth Amendment. The Fourth Amendment to the United States Constitution states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." That word unreasonable is doing an enormous amount of legal work right there. It means the government can search you and seize things from you, but only when it's reasonable under the law. Now, for most of American history, reasonable meant a warrant or probable cause, a real, solid reason to believe you committed a crime. But in 1968, everything changed. October 31st, 1963. Halloween. Downtown Cleveland, Ohio. A veteran police detective named Martin McFadden is on his regular beat. He notices two men, John Terry and Richard Chilton, walking back and forth on the same stretch of sidewalk, over and over, 24 times, pausing to stare into a store window each time, then meeting on a corner to talk. McFadden, with over 30 years of experience, recognized this. He believed they were casing the store for a robbery. He approached them, identified himself as a police officer, and asked their names. When they gave unclear responses, he patted down the exterior of their clothing and found concealed weapons. Terry was arrested, convicted, and appealed all the way to the United States Supreme Court, arguing that McFadden had violated his Fourth Amendment rights because there was no probable cause. In 1968, the Supreme Court ruled 8-1 against Terry, and in doing so, created the legal foundation for every police ID stop in America. The court held that a police officer can stop and briefly detain a person without probable cause and without a warrant if the officer has reasonable suspicion based on specific and articulable facts that criminal activity is occurring or is about to occur. This is now called a Terry stop. The key phrase, specific and articulable facts, not a hunch, not a feeling. The officer has to be able to explain in specific detail why they found your behavior suspicious. That one case, Terry v. Ohio, is the legal foundation everything else builds on. Now, fast forward to 2004. A Nevada man named Larry Hiibel is standing outside his truck on a rural road. Someone had reported a fight. A deputy sheriff arrived, spoke to Hiibel, and asked him 11 times to identify himself. Hiibel refused every time. He was arrested and convicted of obstructing a police officer for refusing to identify himself. He appealed, arguing his Fifth Amendment, the right not to incriminate yourself, and his Fourth Amendment rights protected him. The case went to the U.S. Supreme Court. In Hiibel v. 6th Judicial District Court of Nevada, decided in 2004, the court ruled 5-4 that Nevada's stop and identify law was constitutional. The court's reasoning was this: if a state passes a law requiring you to state your name during a lawful Terry stop, your name alone is not self-incriminating under normal circumstances, and requiring it doesn't violate the Fourth Amendment if the stop itself was lawful. But here's the part that changes everything. The court also made clear that this only applies if your state has actually passed a law saying so, and that is where it gets complicated. As of 2024, 26 states have some form of stop and identify law. The other 24 states, plus Washington, D.C., have no such requirement. In a stop and identify state, if a police officer has a lawful, reasonable basis to stop you, you may be required to give your name and sometimes your address and date of birth. Refusing could result in arrest. In a non-stop and ID state, like California or Texas, there is no law requiring you to identify yourself, and you can legally say nothing. States with a stop and ID law include Alabama, Arizona, Arkansas, Colorado, Delaware, Florida, Georgia, Illinois, Indiana, Kansas, Louisiana, Missouri, Montana, Nebraska, Nevada, New Hampshire, New Mexico, North Dakota, Ohio, Rhode Island, Utah, Vermont, and Wisconsin, among others. States without a stop and ID law include Alaska, California, Connecticut, Hawaii, Idaho, Massachusetts, Michigan, Minnesota, New Jersey, Oregon, Pennsylvania, South Carolina, Tennessee, Texas, Virginia, and Washington, D.C., among others. But here's the critical catch that even most residents of those first states don't know. Even in a stop and identify state, the officer must have reasonable suspicion first. They cannot randomly walk up to you on the street with zero justification and legally demand your ID. That is what almost nobody knows. Now let's talk about the 3 specific situations you could find yourself in, because the rules are completely different for each one. The first scenario, you are driving a vehicle. This one is simple. If you are operating a motor vehicle and you are pulled over, you must show your license, registration, and proof of insurance in all 50 states. No exceptions. Operating a car is a privilege, not a right, and you consent to identification requirements the moment you start driving. The second scenario, you have been detained. If an officer says the words, "you are being detained," or if by their actions it's clear you're not free to leave, like blocking your path or ordering you to stop, you are in a Terry stop. At this point, in a stop and ID state, you must give your name, period. In a non-stop and ID state, you have the constitutional right to remain silent. You can say calmly, "Am I being detained or am I free to go?" In both situations, you do not have to answer any other questions. Beyond your name, in applicable states, you have the right to remain silent under the Fifth Amendment. The third scenario, and this is the most important and least understood, you are having a consensual encounter. A consensual encounter is when an officer walks up to you but has not detained you. They are asking questions voluntarily. In this scenario, in every single state, you have zero obligation to answer anything, show ID, or even stop walking. The catch is you might not know which situation you're in. That is why the single most powerful question you can ask any police officer is, "Am I being detained or am I free to go?" If you are free to go, walk calmly. No argument, no last word. If you are being detained, now you know your rights apply. This is where the stakes get real. Only 7 states specifically make it a crime to refuse to identify yourself when lawfully detained: Arizona, Florida, Indiana, Louisiana, New Mexico, Ohio, and Vermont. In Arizona, refusing to state your true name when lawfully detained is a Class 2 misdemeanor under Arizona Revised Statute Section 13-2412. In Indiana, refusal to give your name, address, and date of birth is a criminal offense under Indiana Code Section 3428.5.3.5. In most other stop and ID states, refusing may allow an officer to hold you while they investigate further, and in some cases, courts have allowed an arrest on obstruction grounds. In states without a stop and ID law, refusing to give ID during a lawful stop generally cannot, by itself, be used to arrest you. But be warned. Officers sometimes still make arrests that later get challenged in court, and that is a stressful, expensive situation nobody wants to be in. And there is one absolute rule in every state, in every situation, no matter what. Never give false identification. Providing a fake ID or lying about your name to a police officer is a crime everywhere in the United States, even in states where you have no obligation to speak at all. So here's what you should actually do if you are stopped by police. Number 1, stay calm. Your composure is your greatest asset in any police encounter. Number 2, ask clearly, am I being detained or am I free to go? This single question establishes the legal framework of the entire encounter. Number 3, if you are free to go, leave calmly. No argument, no last word. Number 4, if you are detained, know your state's law. In a stop and ID state, give your name. Beyond that, you may politely say, I am choosing to exercise my right to remain silent. Number 5, do not physically resist. Even if you believe the stop is unlawful, the time to fight an illegal stop is in court, not on the street. Resisting a stop, even an unlawful one, can result in separate criminal charges that follow you for years. Number 6, if you believe your rights were violated, document everything you remember immediately after. The time, the location, the officer's badge number, exactly what was said. Then consult an attorney. Here's the bottom line. The United States Supreme Court has drawn a very specific line. Officers need reasonable suspicion to detain you, and whether you must show your ID after that depends entirely on the state you are standing in. The Fourth Amendment protects you from unreasonable government intrusion, but it does not make you invisible to the law. Knowing where that line is, that's the difference between confidently exercising your rights and accidentally making a situation much worse. The law rewards the informed, and now you are more informed than 99% of people walking out their door today. If this video helped you, smash that like button. It helps more people find this content when they need it most. Drop in the comments, what state are you in, and did you know whether it was a stop and ID state before watching this? I read every comment. Subscribe to Legal Logic so you never get caught off guard by the law again. New videos every week breaking down the laws that affect your real life. In plain English, no law degree required. Links to every case and statute we cited today are in the description below. Stay informed, stay protected. I will see you in the next one.